Hello and welcome to the Data Privacy Lawyer. My name is Funmi Owolabi. I'm the principal attorney at the firm. Today's review, we're going to be looking at some terms belonging to an AI service provider. So we've got the cookie banner. I'm familiar with this tool because I sometimes use it. And sometimes I have individuals that I'm speaking with that actually subscribe to Otter.ai. Essentially, it helps take notes related to like your meeting. I'm not familiar with every single offering that they have, but I know for a fact that they definitely process information related to audio recordings, voice recordings, both of which are personal data. So I thought a review of the terms of service would be valuable because I have interacted with this tool. And then also, I think given the fact that many organizations are now integrating or purchasing or procuring different AI solutions to improve their business efficiencies, it's valuable for organizations to understand what the terms of service are when it comes to interacting with artificial intelligence. Now, the bulk of my practice, if not all of it, is centered on providing advisory to business organizations that process personal data. In 2026, I don't know any organization that doesn't at least process some personal data. So it's really important for you to understand what's at stake for your organization and what types of risks are inherent when you liaise with a service provider to whom you provide personal data. So I think it's important to look at what's in scope. The Otter voice meeting notes tool, which I'm familiar with, along with our website, along with other related networks, applications, mobile applications, and other services provided by us. This service enables users to transform recorded voice conversations, which I had mentioned a couple of minutes ago, into transcribed notes that can be shared and searched. You may choose whether to use the free version of the service or the subscription-based paid version of the service, for which you may be required to pay fees. You must be at least 13 years old to use the service. I'll explain why the sentence exists. I think that the sentence exists because in the United States, the threshold for what constitutes a child under the COPPA data protection law, which is a federal data protection law that dictates how children's personal data can be processed, the age threshold for that law is 13. Now, in other geographies, it's different. If this service is being provided in the European Union, the age range can be 16 to 18 for a child, depending on the country. But in the United States, what constitutes a child under COPPA, which is the children's privacy law, is 13, which is why this sentence probably exists here. So essentially what they're saying is two things. One, they're cognizant of the fact that COPPA is a federal privacy legislation that may apply to the use of their tool, but they're also trying to avoid any responsibilities associated with processing children's data that come from having to adhere to COPPA. Let's say, for example, you have a tool, and the tool is something that is aimed or targeted at children. There are going to be additional responsibilities you have if your target market is under the age of 13, and that's in compliance with COPPA, the data protection law for children. This sentence says we are not targeting children, so the obligations that come under COPPA are not going to apply to us. You shouldn't be using this tool if you're not at least 13 years of age. To access most features of the service, you must register an account. Again, we can see if you, an individual, are registering an account, you are going to be providing information like name, which we know is personal data, email address, phone number, or other contact information. So this sentence tells me a couple of things. One, this organization definitely processes personal data. And two, they most likely meet the threshold in lots of geographies based on what they've listed in this sentence. Every country is going to have its metric that is required to be met for a law to apply to you. In some geographies in the United States, the threshold is if you are as a business process the personal data of 50,000 of our residents, you need to look at this privacy law and you need to comply with this privacy law. In other geographies, it's do you process personal data in our geography? Do you obtain the information of residents in this country? If you obtain their information and you sell them a product and service, you need to adhere to the law. So there's lots of considerations that this service provider is going to have. Now, as we continue to go through this, we'll see if they offer an enterprise solution. I don't know if they do. Most of the interactions I've had with Otter.ai have been just individuals, as opposed to a solution that's offered by a company that is then distributed to end users within the company. But those would be questions that I would be asking if I was counsel for Otter.ai, because I need to be very familiar with the product and service to be able to provide advisory on what provisions need to exist within the terms. For basic workspace, pro workspace, business or enterprise organizations, which I had just mentioned, if you wish to designate individual users to access and use the services, you may also be required to provide us with some information about these authorized users. So they do actually have an enterprise solution. You agree that the information you provide to us is accurate. Now, this is really important. There is a privacy foundational principle that requires for data to be accurate and up to date, and it's really important for a number of reasons. The obligations that are associated with a business when they process personal data, we need to make sure that the personal data is actually accurate, because there are responsibilities that Otter.ai has related to that personal data. If it's not accurate, it could jeopardize the privacy program of an organization, depending on what the inaccuracy is. Now, this really does depend on what the program for a business already looks like, but accuracy is very important when it comes to personal data. And I'll give an example of when accuracy is going to be very crucial. If a business experiences something called a data breach, let's say, for example, a bad actor obtains information that belongs to an organization, it's going to be very important to have accuracy around what data was included in that breach in the event that an organization has breach reporting obligations. Now, I won't go down that too much, but there's a lot of considerations that a privacy lawyer is going to have when it comes to negotiating a contract for a business and providing advisory on what each sentence means, what each terminology means. Let me just see above. I wanted to see if there were definitions associated with this term, because sometimes customers are signing up for terms that they don't understand and that their service provider hasn't provided definitions for. That being said, they do have definitions, but the definitions exist in the data processing agreement. They don't exist in the terms of service. So that's an important distinction. That being said, because the terms of service and the data processing agreement are both on the same page, it's something that I presume the terms associated with the DPA are also applicable in the terms of service. Now, I can't say that for sure. Do these terms in the DPA also apply in the terms of service? Sometimes they're slightly different, and that's something that customers should be aware of. Let's go back to the terms, because that's really what I wanted to look at. Let's look at the user content section. Certain features of the service may permit users to upload content to the service, including by syncing your account with third-party accounts as further described in 9.1, including voice recordings, audio recordings, data, and I presume this includes personal data, text and photographs, and to otherwise publish user content on the service to the extent you desire to use the service in connection with materials or information located on your Zoom, Dropbox, or other third-party accounts. You hereby grant Otter.ai permission to access the third-party accounts in connection with the service. The voice recordings, let's talk about this. This is personal data. The service may provide a feature that allows you to record individual conversations and or upload recorded convos. The laws regarding the notice and notification requirements of such recorded conversations vary by locations. This is really important. I've talked about how the data protection laws vary by country to country. How a voice recording can be processed in that geography is going to be determinant on what the privacy laws are in that country. It's your responsibility as a customer to know that. It's also the responsibility of the service provider to know that. Because as far as I can tell for now, Otter.ai likely is going to be storing these conversations. Now, storage is considered a processing activity under the data protection laws. Processing covers any operation or set of operations on personal data. If you are conducting a processing activity, for example, you're an enterprise customer and you distribute Otter.ai to all of your employees, and your employees are allowed to record individual conversations and or upload recorded convos, you're responsible for that data because you determine the means and purpose of processing. Otter.ai's responsibility is, if they're going to be storing this data, they operate on your instructions, and they have responsibility under the data protection laws that vary by location. So they have a responsibility to know how they can process this information, but you also have a responsibility to know how you can roll this out and what type of restrictions you need to ask your service provider to put on the processing of this information depending on the geography. Now, I know that's really long-winded, but one of the things that's really crucial for businesses to consider when negotiating any type of contract is, has my privacy counsel reviewed how this contract affects my current business operations? And what do we need to put in place in order to utilize this solution? There's a lot of different questions. Access to user content and results. Otter.ai may permit you to share certain user content or the result of user processing. We've got this sentence again. I think a lot of companies in 2026 are moving away from the word using personal data to processing personal data, because processing covers any operation or set of operation on personal data, and they want to be able to capture that in your usage of their solution. So the word processing is very crucial, and I anticipate in 2026 more and more terms of service or terms of use are going to include this terminology, because it is all inclusive for many geographies where a solution may be offered. With other users of the service, share user content or the result of processing user content outside the service, or even make certain user content or the result of processing user content public for all to view. You acknowledge and agree that although Otter.ai may provide certain features intended to allow you to restrict access, Otter.ai does not guarantee that such user content or any results of processing user content will never be accessible by others. I'm intrigued about this. I think I would need more inside knowledge to be able to understand what this sentence is referring to. And this is why it's important. I'm highlighting this because it's important for you to give a lot of information to your privacy counsel on what your products do. Because without understanding the product in depth, privacy lawyers are not going to be able to draft appropriate language to address their responsibility as a service provider and then the responsibility on the customer. One of the things I do within my own practice is I always ask clients to fill in a very extensive intake form, because every company is different. The offering that Otter.ai has and the way in which their products work is going to be different to another solution that utilizes artificial intelligence. No individual term is going to be something that can be translated from company to company, because each of your products and services operate differently. And that's why I've highlighted this. Otter.ai shall have the right to collect and analyze data and other information related to the provision, use, and performance of various aspects of the service and related system and technology. I want to highlight this. The term personal data is any identifiable information on a person. That's it in layman's terms. The reason I've highlighted this is the traditional definition of personal data, like what most people understand personal data to be, like name or email address, is not necessarily what constitutes personal data under some respective data protection laws. As long as there is a piece of data that could identify an individual, it constitutes personal data even if it's not known to be so in the traditional sense. For example, an IP address is considered personal data under the data protection laws because it could identify an individual. Most people and most individuals don't recognize that an IP address is personal data because it's not like name or email address. It's the business's responsibility to know that intricate detail. And if the business doesn't know, they need to seek counsel to be able to understand what their obligations are. I've highlighted usage data because sometimes there is usage data that constitutes personal data. And sometimes in the terms, businesses will identify what constitutes usage data, sometimes they will not. It's the responsibility of this organization to know whether or not their usage data does constitute personal data and to act accordingly. Okay, I really hope you enjoyed this review. If you have comments or questions about my opinions on these terms, leave a comment below and I'll see you in another review.